like to thank all members of the Legislative Council for their work behind the scenes prior to this sitting. This includes the extensive scrutiny that they have performed on all stages of the passage of the bill through the House of Keys, as well as the meetings and discussions that they have held with individuals and groups as an alternative conduit for people opinion and input. In addition, I would also like to thank honourable members for their involvement with meetings and discussions that I have arranged during the recess period with the proposal of the bill in the House of Keys, the drafter from the Attorney General's Chambers, and the then DHSC Minister. These meetings and discussions primarily covered specific elements of the bill, amendments that have been made in the House of Keys, the wording and meaning of specific clauses, and how this will be implemented on Ireland if passed. I also appreciate the work done by honourable members to examine other jurisdictions that have implemented forms of assisted dying legislation and those who are in the process of trying to do so. The bill before us is to enable certain adults who are terminally ill to be able to choose to be provided with specific assistance to end their suffering, to choose to end their own life. It is about choice for those who are about to die. I fully respect that many people would not wish to make that choice, but this bill is for those who do. The extensive debate in the House of Keys made a number of amendments before passing the bill with a 2/3 majority. The principles of this bill, as amended before us today, are as follows. The bill is to enable persons who are diagnosed by a registered medical practitioner to be terminally ill, and where that person is reasonably expected to die within 12 months, for them to be provided at their request with specific assistance to end their own life. Mr. President, this bill only applies where the person has the capacity, as defined under the Capacity Act 2023, to be able to make a decision to end their own life because they do not have an impairment of or a disturbance in the functioning of the mind or brain, and it only applies where the person has been informed about their diagnosis, prognosis and treatments available, and only applies where the person has a clear and settled intention to end their own life, reached voluntarily without coercion or duress, and it only applies when the person has made a formal declaration to that effect. The bill only applies if on that day, the declaration is made, the person is aged over 18 and the person has been an ordinary resident in the island for not less than 5 years. The bill also sets out in detail how and by whom assistance in dying may be given, and also recognises and respects that persons, including healthcare professionals, may have a conscientious objection and do not wish to exercise functions under the Act. It also recognises that those healthcare professionals who do intend to exercise functions under the Act will notify the Department of Health and Social Care and ensure that they have received the appropriate guidance and training from that department before doing so. Another key principle of the bill is that no healthcare professional should be under any duty by contract, statute or any other legal requirement to raise the subject of assisted dying with a patient or to offer assisted dying to a patient as a treatment option. The bill makes it clear that a person who provides assistance in accordance with this Act, does not commit an offence under the Criminal Law Act 1981. The Act also makes it clear that when a person dies only as a result of lawful assistance, no inquest is needed. Other principles cover the codes of practice that the Department of Health and Social Care may issue and how the Department shall monitor and report on the operation of the Act. The bill before us addresses offences that a person may commit in relation to, for example, coercion, pressurisation, creating a false declaration and destroying a declaration made by another person. The bill refers to the penalties that will be incurred by those actions. Finally, the bill sets out the wording of the form of declaration that would need to be signed by the terminally ill person and witnessed by someone who is not a relative of that person, is not directly involved with that person's care or treatment, and is not someone who would gain financially from that person's death. The declaration must also be countersigned by the attending doctor and an independent doctor. In conclusion, medical treatment and palliative care has improved dramatically over recent years. Many more patients are surviving longer, being offered newer treatments and the choice of more effective pain control. But there are still times when medical and scientific advancement is not enough. Some terminally ill patients will still experience severe physical or emotional distress that cannot be relieved. Some of those terminally ill patients will wish to be able to make the choice to end their own life in a controlled and dignified way. That is what this bill is intended to achieve.